7, the rule of law. Essentially, this is going to talk to us about all the things that police have to know. I would love to hear from anybody if you're interested in being a police officer. It's critically important for those that want to be a police officer to know just how much they have to know about the law. They don't have to be an attorney per se, but they sure do need to know a lot of information about the law. And that's what we're going to talk about in Chapter 7. The first thing, due process requirements. It's critical for me that you understand the 4th, 5th, 6th, and 14th, not just if you want to be a police officer, but really for your own individual due process rights. Most due process relates to one of 3 areas: evidence, search and seizure, arrest, and then intelligent gathering. We'll talk about those as we go on. So the 14th Amendment is one that says, really came about under the Warren Supreme Court. It was the Due Process Revolution. And essentially it said that the state shall make or enforce any law should not enforce any law which shall abridge the privileges or immunities of citizens of the U.S., nor shall any state deprive any person of life, liberty, or property without due process. So essentially making sure that under this amendment that somebody else is checking off the boxes. There's some checks and balances to make sure that there's not a rogue police officer or a rogue judge that's just arbitrarily saying, oh, by the way, I'm going to throw you in the prison without you ever knowing about anything. And so, when we go to the 4th Amendment, that's intended to limit overzealous behavior by the police. This is impacting searches and seizures, arrest, probable cause, PC. You'll see throughout the audio that I'll reference PC throughout the PowerPoint slides is the standard for legal arrest or search. And then we'll talk about absent exceptions to or exigent circumstances. Probable cause is more than just a mere hunch, but less than actual knowledge. All right, so that probable cause is more than a mere hunch. So they can't just be like, well, I think you might have been the individual that went and robbed this store. It has to be more than a hunch, but it doesn't have to be explicitly, you know exactly who it was that robbed the store. And so when you look at evidentiary standards or the degree of the certainty used throughout the various phases of the criminal justice system, you'll see beyond a reasonable doubt that this is level of certainty necessary to find a defendant guilty at criminal trial. 93% certainty. Clear and convincing evidence. This is for a judge, must have in order to deny bail to a criminal defendant. 75. Preponderance of the evidence. This is different. Preponderance of the evidence is different than beyond a reasonable doubt. Beyond a reasonable doubt is a criminal trial. Preponderance of the evidence is civil trial. And you see 50% certainty. We're only with 93 for criminal. Probable cause, again, remember I said it's more than a hunch, so that's at 33%. This is to make an arrest. Reasonable suspicion, this is to actually frisk someone, they have to have 25% certainty, and then that's your hunch. It's not necessarily, but you think maybe, and that's below 20%. And so the exclusionary rule is really important for us when we're talking about when police are doing their job, what can't they use? And so the exclusionary rule is evidence obtained in violation of the 4th Amendment that cannot be used at trial, all right? And so when we talk about exclusionary rule, we're talking about evidence that has been established as a result of an unreasonable or illegal search is not admissible in a federal criminal prosecution. Mapp versus Ohio in 61 prohibited illegal obtained evidence from being used in state courts. Essentially, they were saying that since the right was also incorporated, remedy should be too, it was necessary to deter police misconduct, and that states have been adopting since then. So the idea is that for exclusionary, so what can we actually exclude, or what is admissible? And so illegally seized evidence. So if police officers don't announce that they're police officers, if police officers don't follow the rules and regulations of due process, they can actually not use the evidence. So they could do all this hard work, and then if they violate the exclusionary rule, their information that they get could be held inadmissible, which means not used. So illegally seized evidence, contraband, that could be drugs, it could be receiving stolen property, it could be jewelry from a house burglary, fruits of the crime. So whatever individuals got from the crime, if the police did not do a proper search, then that case may fall apart in court. Okay? And so we see here fruits of the poisonous tree. So, the Police Act was illegal. And it doesn't even matter that the police didn't intend to or didn't mean to do what they did. It's simply that they didn't follow the rules of law. So for those that want to be police officers, it's so critically important for you to understand what are all the rules that you have to follow to make sure that due process was followed and that your hard work will not be thrown out in court. And so if the Police Act was illegal, evidence illegally obtained is admissible, evidence obtained from illegally obtained evidence. And so that is the fruit of the poisonous tree. So what's happening is the police do something illegal. They don't follow the rules, due process. They get evidence, and now it is considered fruit of the poisonous tree. And then they're, since it's tainted, if you will, then it's not going to be able to be used in court if it followed, if it stemmed back from this illegal Police Act. We talk about exceptions to the exclusionary rule. So, police can actually violate due process, or not follow. Maybe not follow due process is more proper. If there's public safety, if there's inevitable discovery, and also for the good faith rule. So these are 3 reasons why police could possibly go beyond the exceptions to the exclusionary rule. Others would be impeachment exception, post-convictional federal habeas corpus. We'll hear about habeas corpus later on in the semester, but habeas corpus is bringing the body forward, so essentially bringing the case forward to the court. Private party exception, there's civil proceeding, police good faith exception. So they didn't know that they were actually violating. They didn't know, and they had good faith that the evidence that they were getting was good faith, and so it shouldn't have been inadmissible. Grand jury and agency. And so for folks that actually like the exclusionary rule, they say that it really deters zealous police and prosecutors. So it really protects the general public. They would also suggest that it manifests society's refusal to convict lawbreakers by relying on official lawlessness. So again, if you have some rogue prosecutors or some police officers and you believe that they didn't do their job, you then would be in support of exclusionary rule to make sure that they're following what they're supposed to do. It results in the freeing of guilty in a relatively small proportion. So remember, the police can still supersede the exclusionary rule if there's exceptions, right? Good faith exceptions. So if the police say, gosh, I didn't know that I didn't do the due process, and this is why, or it was, imminent circumstances, so there was public safety. So honestly, like most of the time of those that go free, it's not that big of a proportion. It's led to more professionalism against police, saying, yes, that police need to know how to do their job. And if they don't, then we as a community will hold them accountable and say, nope, you did not do your due process for the public. So that's why this evidence is not going to be used. It preserves the integrity of the judicial system. Those that are in support of the exclusionary would say that it allows for people to have faith. That, in fact, if something's wrong, they would have faith in the police and what they're doing. Prevents the government from profiting from its wrongdoing and protects constitutional right to privacy. Alrighty, and then those that are against the exclusionary rule would say that it's wrong to make society pay for an officer's mistake. So what that's suggesting is that the crime really happened. The officer was not intentionally, perhaps, or maybe, getting evidence that's illegally seized. And so that since the crime happened, we shouldn't allow that crime to go sentenced or unconvicted because the crime actually occurred. So just because the police made a mistake, now someone's going to get to go free. They would say that those that are against the exclusionary rule, it excludes the most credible, probative kinds of evidence. It discourages internal disciplinary efforts. So discouraging efforts from law enforcement so they don't punish individuals that, punishing individuals that got fruits of a poisonous tree are not in favor of those that are against the exclusionary rule don't like that. It diminishes the It diminishes the respect for judicial process and generates disrespect for the law and administration of justice. And then, the idea is that if it's there it's really there just to make sure that deterring police misconduct because all their work will not be met for good, that who knows? Does it really, in fact, deter police misconduct? We don't know, right? There's not a lot of research to say. Only the United States uses exclusionary rule, others do not. It has no effect on those large areas of police activity that don't result in criminal prosecutions. And then the other against the exclusionary rule is the rule is not based on the Constitution, only the invention of the court. It doesn't punish the individual officer whose illegal activity led to the exclusion, because what it does is it could. These are those that are against, saying it doesn't, but it really could. So if an officer continually gets fruit of a poisonous tree, it actually could potentially harm that particular office. And then Supreme Court Justice Scalia had said it's been universally rejected by other countries, so therefore we shouldn't have it. So you can decide whether you think that the use of the exclusionary rule for police to make sure that they are using the due process is something that you support or not. So I just gave you some ideas. So the right to a constitutional arrest. So constitutional arrest, like I told you before, you have different levels of a hunch versus a probable cause versus reasonable suspicion. So a constitutional arrest is satisfied when the time of arrest, the facts and circumstances are sufficient that a person would believe, a reasonable, prudent person would believe that a crime has been committed and the suspect committed the offense. That's probable cause. So arrest warrants require, number one, valid if it's based on sworn complaint by a neutral magistrate or a judge, depending on if you're rural or urban, that sets forth the facts showing the commission of an offense and that the right and that the accused is responsible, and the right of this to a citizen arrest is determined by the state. So exceptions to the probable cause is sometimes permissible for a person to go to the police station for investigation. These are lineups, hair samples, voice samples, photography. Stop and frisk is permissible if prompted, but this is a temporary detention, and so we'll talk a little bit more about Terry versus Ohio Seminole case. And then a person may not use excessive force or resist arrest unless the officer uses excessive or necessary force. And so the idea is that if the police officer is if the alleged defendant is using force, then of course the police officer can rise to that level commensurate with whatever they're seeing in their alleged defendant. All right, warrantless arrest. So these are exigent circumstances. So these are situations that are exceptions. So we typically want warrant arrests. So we want to have, again, a neutral magistrate or judge swear out a warrant, have the police officers serve the warrant on the alleged defendants. And so sometimes there's exigent circumstances to have a warrantless arrest. So in 79, the Supreme Court ruled that the police may not randomly stop a single vehicle to check driver's license and registration, that this in fact was racially biased, that it was specifically, there was no reason why you needed specifically to have a warrant to be able to stop people. In 1990, the court ruled that stopping of all vehicles passing through sobriety checkpoints did not, though, violate the Constitution. Police are not required to give drunk driving suspects Miranda warnings, and then police may arrest everyone in a vehicle in which drugs are found. So these are warrantless arrests. So that last one, for my college students that are in a car smoking dope, if anybody's ever told you, you're all could be complicit, and that's really why, is that if a police officer smells weed and no one's being able to say it's mine or I'm smoking it, all others in the car could in fact be they could actually do a warrantless arrest. They don't need to go get a warrant. So unreasonable search and seizure, this is another thing to make sure due process is happening. Government conduct requirement prohibits unreasonable searches by police or private citizens at the police discretion, or private police, or public school officials. And so reasonable exception of privacy is required before Fourth Amendment protections are valid. The defendant has to have standing in the place, so to be searched for the expectation of privacy. No reasonable expectation of privacy in things held out to public, including handwriting, voice, phone numbers, bank records, magazines, open fields, open garage, paint on a car. So because these are in public, it is not unreasonable to search them. Search is conducted pursuant to a warrant. So the reasonableness requirement, the neutral detached magistrate requirement, the probable cause requirement, and then constitutional execution of a search warrant. Police must execute the search warrant in the time that they said that they would. Announcement, they have to be able to make that they're announcing it. The scope of the search must be clear. So they can't come into a warehouse that's a ginormous warehouse and then have the magistrate say, you can only search. This warrant will only cover where the criminal record. Where the records are being held for that company. And then you go there and you think, well, let's go ahead and make it bigger and search all other warehouses. No, it has to be specifically to the scope of search that the magistrate okayed on. And then detention of citizens during a search is okay. Search of a third-party premises, like I just said, requires warrant to arrest. So if you find out that there's another thing that you want to go ahead and look at, you just need to go back to the magistrate and say, I need to expand this warrant. All right, so here's some exceptions to the search warrant. Lawful arrest exception. So if the police are looking for weapons and they believe that there is an imminent concern, they can actually go ahead and arrest without having a search warrant. A stop and frisk. Upon an investigatory stop, a reasonable suspicion. So again, that's reasonableness. If a prudent, reasonable person would come in and say, yep, this is stop and frisk. So if a reasonable person would say yes, then we could say that we can actually do a stop and frisk. That's gone back and forth in the courts. Automobile exception, boats, planes, motorhomes. So these are anything outside of an actual structure home. Typically, they have to have probable cause. However, they can search compartments or containers, including personal containers, like I said, in your car. Plain view exceptions. So these are when police are legitimately on the premises and objects in sight can be taken without a warrant. So when a police officer walks up to your car and there's drug paraphernalia in plain view, yeah, they're going to go ahead. They don't need to have a warrant. You don't need to say, hold on, I'm going to go to a magistrate, I'm going to get a warrant, I'm going to come back and I'm going to arrest you for drug paraphernalia. Nope. They can actually, in plain sight, they can do. Consent exception. So if a third-party consent is usually okay, consent is valid if police believe the person had the right to give consent. So again, this is back to good faith. So they're looking for a serial killer. Alleged serial killer lives with his mom. Mom says, sure, you can go ahead and look at his room. And alleged serial killer comes back and says, oh, no, she didn't have the right. Well, if the police thought that the mom had the right to be able to search it, then yes, we're going to go ahead and use the evidence found. So exigent circumstances, evanescent evidence, so that's blood alcohol content, that's nail scrapings, when you're in hot pursuit. So this is also something that has been back and forth with the court. Should individuals actually be able to chase a fleeing vehicle, or should they wait later on and pick up the individual and said car at a later time? And then again, if emergencies, fires, things like that. Okay, exceptions to the search warrant. Automobile exceptions. Cars have limited exception of privacy based on mobility, but probable cause is still necessary, right? Again, smoke is probable cause if we're looking at marijuana smoke. Smell is probable cause. Something in plain view, probable cause. And these are all the cases just simply saying, in 2011, attaching a GPS device on a car is considered an invasion of privacy. So this is an interesting case, U.S. versus Jones in 2011. So police officer attached a GPS, and the court held that, in fact, that is violation of somebody's freedom of privacy to just hold a GPS. So it'll be interesting to see how that actually plays out later on. So plain view searches, like I said, taking an item in plain view does not constitute a search. It's easy. They can do it. Plain view extends beyond what you see and can sometimes other senses, like I'm saying, your smell, your hearing. So again, if you or others are doing something that you would know would be illegal, make sure it's not in plain view. Alrighty? because the police do not need to get a warrant for that. Electronic surveillance, so these are just some cases where wiretaps in 1928 were not considered illegal searches. 1967, they overruled this, saying that in fact any form of electronic surveillance has to adhere to the Fourth Amendment protections. Police cannot have a warrantless monitoring of an electronic beeper in a private residence. And then in 2013, probable cause is required to search a cell phone. Search incident to arrest is not enough, must have a warrant. So what this is saying is that it's making it tighter for due process for citizens to make sure that the police are following the rules. So Fifth Amendment is you can't, compel yourself in any case. You can't, you can't be coerced. So constitutional confession requires passing 4 hurdles. Number 1, it has to be truly voluntary. To be voluntary, you have to be able to be in your right mind and be able to give consent. So you can't be intoxicated. So you can't be of low cognition. So are you of low cognition that you don't understand what the police officers are saying? Right to counsel must be protected, privilege against self-incrimination, and then no violation of the 14th. So we look at the 15th, we're just simply saying you can't, it's a protection against self-incrimination. What started this whole PowerPoint was Miranda versus Arizona. Once arrested, warnings must be given before interrogation can occur. But again, like always, there's some exceptions. Miranda only applies when there's an interrogation, not just an arrest. No need to provide Miranda warnings during just a routine traffic stop because it's a temporary detention, not an arrest, unless it's for DWI. And then once you invoke Miranda, all questioning must stop unless you restart the conversation. So if you start the conversation, the police officers are good as gold. So if there was a failure to be read rights, a lot of times people will think that if they are arrested and not quote unquote read their rights, they can escape punishment. That's not necessarily true. However, if the police fail to read a suspect his or her Miranda rights, the prosecutor can't use for most purposes anything that the suspect says. So it's not that they're escaping punishment. It's just simply saying that they can't use what you said as evidence against you. And so there's concern about, from common citizens about Fifth Amendment entrapment. So due process clause requires fundamental fairness. So the police can induce or encourage a person to commit a crime. So I know there's a bunch of movies on entrapment, but essentially the police officers can't egg you into saying something or into a situation because the actual citizen could say, I would normally have not taken that money or not agreed to drugs or solicitation for prostitution, right? So the focus is on the conduct of the defendant, not the government, as long as the government's conduct is not outrageous, right? So the police may not originate a criminal design and plant in an innocent person's mind the disposition to commit a crime and then induce commission of the crime. So that's really what I just summarized up to make sure that it was of your own volition. So Sixth Amendment is right to counsel at all stages, and this was a really interesting amendment. So you'll see like in Powell versus Alabama, like I've really truncated this, there's tons that can be done on this one, but Powell versus Alabama in 32, you only got a attorney for capital cases. 1963 with Gideon versus Wainwright, you were able to have an attorney for felony cases. Arsinger versus Hamilton 73, misdemeanors were incarcerated. If you had the ability for a misdemeanor, then you can actually have a right to an attorney. And then Escobedo versus Illinois in 64 is really just the basis for making sure that folks understand what they're saying when police officers are saying, hey, you have the right to an attorney and you don't have to say anything, right? What constitutes an interrogation? Police officer asks questions that are designed to solicit information that may incriminate a defendant, right? So the other thing for Sixth Amendment, right to a speedy trial, which is kind of ironic in the United States because we don't do anything speedy in our court system. So they would say right to a public trial, right to a jury trial, or right to a trial by peers, right to confront witnesses so that whomever is coming charging against you, you have the ability to cross-examine them, right to commissary process to obtain witnesses to your defense. So that's you being able to offer another side. And then you also make sure that for the Fifth Amendment that you can't be charged for the same offense twice. And so again, there's been movies about double jeopardy. And so when the jury is impaneled or in a non-jury case, when the first witness is sworn in, that's when this is attached. So exceptions to double jeopardy: if your initial case is a mistrial, dismissed, or overturned on appeal, then the prosecution, whether fed or state, can then bring forward the case again because of mistrial, dismissal, or appeal. So those are exceptions. But other than that, if you were found innocent before for the exact same crime, you can't be charged again. Now, what most smart prosecutors do is charge you on a similar type of crime, not that one, to see if they can bring evidence forward if they didn't get you, if the first case was not to their liking. Okay, and so that's all the information that I'm going to talk about today for legal aspects. I hope that you found it